Your Honor, this island has been HOA property for nearly 30 years. Victoria Hale said it, like the case was already over. Her attorney had just spent 20 minutes walking the judge through permits. Subdivision maps, construction approvals, and paperwork for 26 luxury cabins, a private dock, and a multi-million-dollar resort the HOA had finished 6 weeks earlier. Then the judge looked at me. Mr. Cole, do you have anything showing otherwise? I reached into my briefcase and pulled out one yellow document, the original deed. Victoria stopped smiling because those 26 cabins weren't sitting on HOA land. They were sitting on my private island, and the worst part for Victoria was that I had warned her before the first cabin was finished. She ignored me. Then cabin 5 went up. Cabin 12, cabin 20, and finally all 26. I never blocked the construction crews. I never touched their equipment. I never stood on the dock screaming about my rights. I documented everything, every letter, every photograph, every permit, every dollar they kept spending after they had been told there was a serious title problem. Victoria thought every new cabin made her claims stronger. She had no idea every cabin was making my file thicker, and when the judge finally reached the part of the property record Victoria had spent months pretending didn't matter, the entire HOA board went silent. But to understand why I let this go all the way to 26 cabins, you need to know what happened the first morning a construction barge turned toward my island. 6 months earlier, I was standing at the end of my dock when I heard a diesel engine coming across the lake. At first, I figured it was a delivery boat heading toward one of the larger houses on the eastern shore. Then the barge turned straight toward Coal Island. My island. It was carrying stacks of lumber, concrete forms, generators, plumbing pipe, and enough building material to make it obvious this wasn't to somebody repairing an old fishing cabin. I crossed over in my skiff. 3 workers were unloading material beside a row of fresh survey stakes. The foreman looked up. "You with the association?" "No," I said. "I own the island." He stared at me for a second, then gave a short laugh like he thought I was making a joke. Instead of arguing, he unfolded a site plan across the hood of his truck at the top. In bold letters it read, "Lake Heritage Retreat Phase 1. I scanned the drawing. 26 cabins, a new dock, walking trails, a maintenance building, utility lines. They weren't planning to use one corner of the island. They were planning to develop almost all of it. Coal Island had been in my family since my grandfather bought it in 1947. He built a small fishing cabin there with his own hands. My father learned to swim off that shoreline. I had spent half my childhood sleeping in that cabin with the windows open and listening to water hit the rocks. At night, it wasn't some forgotten patch of land nobody cared about. And it definitely was HOA property. I asked the foreman who had authorized the project. He tapped the signature block at the bottom of the plan, Victoria Hale President, Lakewood Shores HOA. I knew the name. Everybody around the lake did. Victoria had spent years talking about community standards, property values, and protecting the character of Lakewood Shores, apparently. She had decided protecting community character now included building a resort on somebody else's island. The foreman asked whether there was some kind of dispute. I told him there was now. I took pictures of the plans, the survey stakes, the materials, and the equipment. Then I went home. I wasn't going to start a confrontation with 3 workers who were simply doing the job they had been hired to do. Before I touched anything, I wanted to know exactly what Victoria thought gave her the right to build there. The next morning, I drove to the Lakewood Shores clubhouse. Victoria was already there. White SUV, designer sunglasses, leather folder under one arm. She looked like she was arriving to explain a landscaping violation, not why heavy construction equipment was sitting on land my family had owned for generations. I didn't waste time. You authorized construction on Coal Island. She barely looked surprised. Mr. Cole, that island has been part of the Lakewood Shores recreational tract for decades. No, I said. It hasn't. That finally got her attention. Victoria opened her folder and slid a copy of a 1989 subdivision plat across the table. A narrow line ran from the mainland toward the island. She tapped it with one manicured finger. Community access. I studied the map for maybe 10 seconds. I had spent 32 years working around surveys, parcel descriptions, development plans, and easements, and that line did not transfer ownership. It showed access. Those are not the same thing. An easement can give someone a limited right to cross or use part of another person's property. It doesn't automatically make them the owner, I asked Victoria one question. Did your attorney run the chain of title? She smiled. Our counsel has reviewed everything. We have permits. We have board approval, and we have historical use. None of those answers were a deed. I could have explained that to her. Instead, I slid the plat back across the table. Then I suggest you have your attorney look again. Her smile disappeared. You are not going to interfere with this project. I stood up. I'm going to verify the title. Victoria leaned back in her chair. You do that. I did that afternoon. I opened the fireproof document box my grandfather had kept in his house for decades. Inside were old tax receipts, survey notes, handwritten boundary descriptions, and the original deed that put Coal Island into my family's name in 1947. I read every line twice, then I checked the county parcel records. Same legal description, same boundaries, same chain of ownership. No transfer to Lakewood Shores, no deed conveying the island to the HOA. No language turning the parcel into common property. The 1989 plat Victoria had shown me contained a narrow access easement, nothing more, so I did what I had learned to do during 32 years around property disputes. I started a paper trail. I sent certified notices to Victoria, the HOA attorney, the developer, the general contractor, and every board member listed on the project approval. The language was simple. Construction was taking place on privately owned land without the recorded owner's permission. I included the parcel number, the deed reference, the recording information, and I asked them to stop construction until title was properly verified. 11 days later, the HOA attorney responded. 3 pages of legal language. Only one sentence mattered. The association disputes your interpretation of the property records. That was it. Not another deed, not a transfer document, not a chain of title ending with the HOA, a dispute, and they kept building. Cabin 1 got its roof. Cabin 3 got windows. Cabin 5 was being framed. Then Victoria sent me something I still remember almost word for word, a formal HOA violation notice. According to the notice, I had committed 3 offenses. Unauthorized access, interference with contractors, and creating a safety hazard on association property. The last paragraph said, "You are directed to cease entering the island without written HOA authorization." I read that line twice. They were now telling me I needed permission from the HOA to step onto an island my family had owned since 1947. That was when the whole thing stopped being ridiculous and became useful. I didn't call Victoria. I didn't storm into a board meeting. I opened a binder. Section 1 was certified mail receipts. Section 2 was photographs. Section 3 was permits and site plans. Section 4 was every email and letter the HOA sent. Section 5 was a construction timeline. Cabin 6, Cabin 8, Cabin 11. Every time another structure went up, I photographed it from the same point on the shoreline and added the date. Victoria took my silence as surrender. At a board meeting, she told residents the ownership issue had been resolved. It hadn't. Nothing had changed except the amount of money they were spending. Then Cabin 12 went up. 2 days later, I crossed the lake and saw something new bolted to the dock, a polished metal sign, private HOA property members only. I stood there looking at it. Then I photographed the sign, the dock, the cabins behind it, and the old parcel marker less than 10 feet away. For the first time since the project started, I smiled. Victoria had just done something better than send another angry letter. She had put her ownership claim on a permanent sign in public on my property. A week later, my attorney asked the question almost anybody would ask. Why haven't you tried to shut this down immediately? We were sitting in his office with the deed, county records, photographs, and certified mail receipts spread across the conference table. We discussed an injunction. We discussed the expense. We discussed what the HOA would argue, and most importantly, we discussed what they had already done after receiving notice. Victoria had been warned. The HOA attorney had been warned. The developer had been warned. The contractor had been warned. The board had been warned. They all knew the title was disputed, and they were choosing to move forward anyway. That mattered. I wasn't giving them permission to build. I had already told them in writing that they didn't have permission. What I refused to do was get into a physical confrontation with workers or equipment while their lawyers kept insisting they had a legal right to continue, so I documented every foundation. Every invoice we could obtain, every board approval, every photograph after the notices were delivered. Victoria believed my refusal to create a scene meant I had no case in reality. I was letting her decisions speak for themselves. Then I found something that made me look at the project differently. Buried in the resort paperwork was the name of the company scheduled to manage the cabins after opening. Hale Hospitality Management. Vilking, I read it twice. Victoria's last name was Hale, so I asked my attorney a different question. Who owns that company? The answer came back 2 days later. Hale Hospitality Management was controlled by Victoria's husband. That got my attention. Until then, I had been looking at 26 cabins as a property dispute. Now I started following the money. The HOA had told residents the development would raise property values, create a community amenity, and eventually generate revenue for Lakewood Shores. But the management agreement told a more interesting story. Hale Hospitality would receive a percentage of bookings, separate maintenance fees, cleaning fees, administrative fees, and long-term management payments that increased as occupancy increased. The better the resort performed, the more money Victoria's household stood to receive. I requested the board records connected to the agreement in the material we received. There was no clear disclosure explaining to residents that the HOA president's family had a financial interest in the company scheduled to operate the resort. Meanwhile, construction kept moving. Cabin 14, Cabin 17, Cabin 20. The HOA began circulating glossy brochures showing families kayaking beside the island and sitting around fire pits underneath the words. Exclusive Lake Heritage Retreat. I kept every brochure, every email, every advertisement. Then we obtained the project budget. I stared at the number for a long time between construction. Docks, utilities, landscaping, and management setup. The HOA had committed more than $4 million. $4 million on an island they still had not produced a deed showing they owned. And now Victoria had more than pride tied to the project. Her family had money tied to it. That was when I stopped wondering whether this was simply a bad interpretation of an old map. I started wondering how badly Victoria needed that interpretation to survive. Cabin 26 was finished on a Friday. By Saturday morning, the HOA had turned the island into a celebration. White tents near the dock, catered food, a photographer, board members in matching Lakewood Shores shirts, and a banner stretched between 2 trees, Lake Heritage Retreat Grand Opening. Residents arrived by boat. Most of them had no idea how serious the ownership dispute had become. They had been told the project was cleared, approved, legal. Then Victoria stepped up to a microphone. She thanked the board. She thanked the developer. She thanked every resident who invested in the future of our community. Then she raised her glass. This island belongs to all of us. I took out my phone. Victoria spotted me almost immediately. Her expression changed. She walked toward me with 2 security guards. "You are not authorized to be here." I looked past her at 26 completed cabins sitting behind an HOA banner. "This is still my island," Victoria laughed. "No, Mr. Cole, it is T, and if you continue disrupting association property, we'll have you removed permanently." I held up my phone. Are you sure you want to say that while I'm recording?" She looked directly into the camera. "Absolutely." Then she told security to escort me back to my boat. I didn't resist. I didn't argue. I let them walk me off land my family had owned for nearly 80 years while residents watched. Victoria thought that was her victory lap. 3 days later, the HOA was served. Not with another warning, not with another letter, with a lawsuit asking the court to determine ownership of Cole Island, and Victoria did exactly what I expected her to do. She doubled down. The HOA filed its own claims. They asked the court to recognize the Association-S rights over the island. They wanted attorney fees. They wanted damages for what they called my interference with association property. They even wanted an order restricting me from entering the island. That was the mistake. Because once they put ownership squarely in front of a judge, permits and board votes weren't going to be enough. They had to answer one simple question. How did Lakewood Shores acquire title? Discovery started. My attorney requested board minutes, legal opinions, title material, development contracts. Emails, management agreements, and project records. Then we found one email. It had been sent before the resort was finished. A board member had asked Victoria, "Has title to the island actually been verified?" Victoria's reply was short. "Council believes the recreational plat is sufficient. We need to stay on schedule." I read that sentence 3 times. She had been asked directly whether title had been verified. And instead of producing a deed, she had pushed the project forward. That email went into the binder. So did the management agreement. So did every certified warning by the time the hearing arrived. Victoria walked into court with 2 attorneys, several board members, and boxes of permits, plats, approvals, and project records. She looked confident. I carried 1 briefcase. Inside were 2 folders and 1 document my family had held since 1947. When the case was called, Victoria's attorney went first. He talked about the 1989 subdivision plat, historical recreational use. Permits, access, the dock, the utilities, all 26 cabins. He argued that the HOA had relied on those records in good faith. Then the judge looked at him. Do you have a recorded instrument showing the association owns the island? The attorney started explaining the plat again. The judge interrupted him. That is not what I asked. The courtroom went quiet. I asked whether you have a recorded instrument showing that ownership of the island was ever transferred to the association. Victoria's attorney looked down at his table, then at Victoria, then back at the judge. No, Your Honor, not a separate deed. My attorney nodded to me. I opened the briefcase. Inside was the same protective envelope my grandfather had used for decades. I pulled out the original 1947 deed. The paper was yellowed around the edges, but the legal description was clear. My attorney provided the court with a certified county copy and placed the original beside it. The judge started reading. Nobody spoke. I watched Victoria for the first time in 6 months. She wasn't looking at me. She was staring at the deed. It described the entire island parcel. The shoreline, survey points, parcel references. Then my attorney placed a modern survey overlay beside the old description. The boundaries matched, including the ground underneath all 26 cabins. The judge looked back at Victoria's attorney. Counsel, show me where this property was later conveyed to your client. He started going through his files. There was nothing. The judge picked up the 1989 plat. This is the document your client has relied upon? Yes, Your Honor. She traced the narrow line running toward the island. This appears to show an access easement. That has been the Association-S position. The judge looked at him. No, your Association-S position is that this gives it ownership of the island. Nobody answered, she continued. An easement may permit a defined use, it does not. By itself, transfer ownership of the underlying property. Victoria whispered something to her lawyer. He shook his head. Then the judge asked the question that changed the entire room. Where does this document authorize your client to construct 26 permanent structures on Mr. Cole's parcel? Silence longer this time. Behind Victoria, 2 board members started whispering. Because the problem was suddenly obvious. Permits did not prove ownership, a construction budget did not prove ownership, an HOA vote did not prove ownership, 26 completed cabins did not prove ownership. The deed did. Victoria finally spoke. We were advised that the island was community property. The judge looked at her, by whom her attorney immediately stood. Your Honor, but my lawyer was already opening the second folder. I leaned toward him. Show them the notices, because proving the island belonged to me was only half the story. The next question was what Victoria knew before the HOA spent more than $4 million building on it. My attorney placed the first certified notice on the table. It had been sent months earlier. Before Cabin 1 was finished, before the resort opened, before most of that money had been spent. The letter identified the parcel, cited the deed, included the recording information, and warned the HOA that construction was taking place on privately owned land without permission. Attached was the delivery confirmation. Then came the notice to the developer, the contractor, the HOA attorney, board members. Victoria's lawyer objected to the idea that simply receiving a claim proved the claim was correct. My attorney agreed, which is why we also have the Association-S response. He handed the judge the letter stating that the HOA disputed my interpretation. Then he placed the construction timeline beside it. At the time that response was issued, only a handful of cabins were substantially underway. The HOA kept going. Cabin 6, Cabin 12, Cabin 20, Cabin 26. My attorney placed dated photographs beside the timeline. Then came the grand opening video. Victoria's own voice filled the courtroom. This island belongs to all of us. A few residents sitting behind the board shifted in their seats. Victoria stared straight ahead. Then my attorney took out the management agreement. Hale Hospitality Management Lolk. Victoria's attorney stood. I don't see how this is relevant to title. It goes to the decisions surrounding the project, my attorney said. The corporate records showed the management company was controlled by Victoria's husband. The agreement gave the company booking commissions, maintenance fees, and management payments once the cabins opened. The judge looked toward Victoria. Was that relationship disclosed? Victoria hesitated. The board knew there would be a management company. That was to my question. The room went still. Was your household's financial interest disclosed to the board? Victoria looked at her lawyer. He didn't answer for her. One of the board members behind her whispered, I didn't know that. A resident farther back said, neither did we. That was the moment the room changed. Until then, a lot of people had been willing to believe the HOA had made an expensive mistake involving an old property map. Now they were looking at Victoria and asking a different question. Why had their money continued pouring into a resort on disputed land when the president's own family had a financial interest in seeing that resort open? The judge did not announce some dramatic criminal verdict. That wasn't what the hearing was about. But on the ownership issue, the situation had become unmistakable. The HOA had not produced a deed transferring Coal Island to the association. My recorded title remained intact, and the other records surrounding the project raised questions the HOA would have to deal with separately. Victoria had spent months acting like one old deed didn't matter. Now that deed had opened the door to problems much larger than a property line argument. But there was still one question everyone wanted answered. What happens to 26 completed cabins sitting on land the HOA does to own? Most people assumed I would demand they be demolished. I didn't. The buildings were there, and the people who had ultimately paid for most of them were ordinary residents who had trusted their board. They had been misled too, so my attorney and I proposed a settlement framework. The HOA would permanently withdraw any claim that it owned Coal Island. The private HOA property signs would come down. Any future operation of the cabins would require a real lease from me, with clear boundaries, insurance requirements, access terms, and written acknowledgement that the underlying land belonged to me. The HOA would cover my legal costs and address damage caused during construction, and part of the revenue from future cabin use would go toward reducing the financial hit residents had taken from the project. Victoria hated the idea. She called it outrageous. Her own board looked at the alternatives: removal costs, restoration, trespass claims, more litigation, and 26 cabins they could not legally treat as their own. Within weeks, the board accepted the basic framework. The first thing I did was remove Victoria's metal sign from the dock private HOA property. Members only. I kept it not as a trophy, as part of the record. Then I installed a new sign: Coal Island, private property, same shoreline, same 26 cabins, completely different reality. The HOA could continue operating the retreat under the new agreement. But now everybody understood something Victoria had refused to understand from the beginning. Permission is not ownership, and every resident who stepped onto that dock could see exactly whose island they were visiting. The bigger changes happened back at Lakewood Shores. The first emergency HOA meeting after the ruling was standing room only. For years, Victoria had controlled those meetings. This time, residents controlled the questions. They wanted the management agreement. They wanted the full development budget. They wanted to know who approved millions of dollars in spending before title was confirmed. And they wanted to know why the president's husband had been positioned to make money from the resort. Within a month, Victoria was out as president. The board ordered an independent financial review. New conflict of interest rules were adopted. Major contracts involving board members or their families required disclosure and recorded approval. Future development projects required documented title verification before construction. And large expenditures had to be available for residents to review. Someone asked me to join the new board. I declined. I had never wanted to run Lakewood Shores. I just wanted Lakewood Shores to stop pretending it could run my island. I did agree to help clarify several old boundary descriptions around the lake. A few months later, families were using the cabins again under the new lease. Kids fished from the dock. People carried coolers down the trails. Kayaks were stacked near the shoreline. The retreat had finally become what Victoria had claimed it was supposed to be, a place the community could enjoy. Only now nobody had to lie about who owned it. One evening I stood beside the dock while the last families loaded their boats. Behind me were 26 cabins, still standing. Still useful. The difference was simple. They were there with permission, not entitlement. Victoria had 26 cabins, a multi-million-dollar project, a stack of permits, 2 attorneys, and an HOA board standing behind her. I had 1 deed. That was enough, because permits don't prove ownership. Votes don't prove ownership, and repeating the words community property does to make somebody else land yours. The truth had been sitting in a document box for nearly 80 years. All anyone had to do was read it. Victoria thought every cabin she finished made her position stronger. In the end, every cabin only made the lesson more expensive. An HOA can manage a community. It can enforce rules where those rules legally apply, but it cannot rewrite a deed. And it cannot turn private property into community property just because somebody with a title, a folder, and enough confidence says so. Sometimes the quietest person in the room isn't losing. Sometimes he is documenting and waiting for the judge to ask the one question nobody else bothered to ask. Who actually owns the land?